I have one important thing to tell you about.
We're all same side.
These are assistant teachers. Just 1 second. One very important fact. These are assistant teachers. We are the untrained one. In trained also, for 269 people, the learned judge made an identical order saying you are out, fresh process to start. There we did not go to the division bench. We brought it straight to before your lordships. Your lordships have stayed the fresh process and also stayed terminated. So therefore it is the same batch, 42,000 posts. And in those cases of those 269, in the first round, he passed a similar order without us being parties, saying throw them all out. That order again came before your lordships. Your lordships, after hearing all of us,
where is that order?
Yes. That order of stay of further process just pass on the interim order.
That is for which category?
That is for the trained. But amongst the same selection process, we are the untrained. So therefore, which order of which state you are part?
Our untrained got trained after 2 years.
Single judges pointed out by a detailed chart.
The single judge
aptitude test not.
No, it's all wrong. That's wrong. How can you do that? How the court, single judge can invoke the section 125 of the Evidence Act. 165. 165 of the Evidence Act.
We are in the writ petition to set aside our appointments. We will go to the writ petition.
The judge called several members of the selection board from different parts of West Bengal to come here. Tell me, did you hold aptitude? Somebody said no, somebody said yes. After 8 years, you called a small officer before the High Court. I said, did you hold? Did you not hold?
And we are not parties.
The learned judge was asking the question, when the answer was coming, they were giving the answer correctly. Then the learned judge is saying, no, you are under fear, you are making a wrong statement.
And that is held in a hall in the High Court, not in the courtroom. As if it's a public hall. I don't know. Please, I want to raise a larger issue. This is already Lordship will understand. Lord, these are batches of teachers which are going on in this court. For the last 6-8 months, we are appearing in at least 25 cases. In every case, people are terminated. The learned judge gives an interview on national television that this is what I have done. I will root out corruption in this fashion. This man will go to jail. I will do this. I will do that. We brought this interview to the Justice of India by a petition. The Chief Justice is ordered by a judicial order that those cases which related directly to the interview should not be heard by this judge. So they were transferred. Then, the judge made an order that the Registrar General of the Supreme Court by midnight.
We are aware of that.
She is aware of.
I have seen in that
my Lord, therefore,
in another case.
My Lord, therefore, it's a larger issue. People can't keep rushing to court. How will
Mr. Rohatgi, don't impress upon by that reason.
No, that's all right.
Not on the merits of the individual.
Fine. How will 32,000?
I have one more important.
Brother, as a citizen,
how do 32,000 people come to court?
Natural justice. Not included even in representative.
No.
The representative who is
I have more.
Just 1 minute. 2016 selection process was done. 2017, this 2016 selection was challenged. One of the single judge has dismissed batch of the writ petitions. Thereafter, another batch of the writ petitions have been filed. That was also dismissed. When only before the learned single judge, when the
same batch, 269 people, the learned single judge passed an order terminating their services just like that, saying fraud, etc., without a single one being a part.
We have seen this.
So that is the second round. I'm talking of first round of this order. So this matter comes before your lordships. By a detailed hearing, your lordship said, you cannot terminate a person's service unless you first implead him as a party. Your lordships stayed those termination orders, directed impleadment.
Can I brief everything?
No. And
can I brief everything on your part?
No.
Can I brief everything on your part?
I'll summarize the whole thing.
All right.
Your saying is, these petitioners were not a party before learned single judge. The order, whatever is passed by learned single judge, that is of fresh selection.
Correct.
By that, which was challenged.
Correct.
Alright, in that challenge, passing an order staying termination without saying that process of selection,
Yes.
how far is justified? This is your point.
Correct.
You have addressed.
Now,
You want to say more than that?
Yes, only one more thing, Milord. I appear for the board. Board is the person who has to do this exercise, which is not state. Now, Milord, 1,20,000 persons will then have to be interviewed, videographed according to Milord the order of the learned single judge. Milord, this is a colossal Milord waste of time and waste of money if it is not necessary. If it is necessary, of course, it will be done. That's why, Milord, till the division bench takes a call, Milord, this process of Milord having interviews of 1,20,000 people, Milord, which will cost Milord in crores.
Let's hear them out. Let's hear the
respondents
in the report.
Because the fact that principles of natural justice have not been complied with is noticed by the single judge and the division bench. They notice that we haven't given notice.
Therefore, termination was there. Therefore, I said you are agreed by that part.
The sequitur is
Usually in pleading may not be possible, but representative capacity should have happened.
at least
For
some
36
should have been heard.
Let's see what they are saying on
Milord, as far
it.
as interviewing is concerned, Milord, the judge indicated who should be called. From the list, Milord, he said you call
We
this
will
man.
not influence upon by that factual aspects, Mr. Gupta.
No, yes, Milord.
Yes,
That is led to Milord the finding that there was no aptitude test by calling certain
I
persons.
saw that chart.
Yes.
He says in certain districts, no aptitude test.
No, Milord, he called certain persons.
Point is this, Milord.
3,100 in all. Now, how does 31 of them representative of what really happened with the other 2,670 others? Why not interviewers?
Anyway, that is for the division bench to see.
Correct.
Yes, but
Now, you all filed appeals.
in the interregnum, if there are no principles of natural justice, can the matter be taken to the next level and to say that no, that process will
that is
be...
the point.
That is the
Next
point,
step.
brother.
We have already pointed
Let us
out
hear
that-
them.
I-
Let us appeal.
Yes, please.
But so far as Milord, in-service candidates are concerned, Lord, they are being protected by the order.
Answer my brother's query.
Yes, please.
You filed the
questions.
petition.
2-3 questions to you. You filed a writ petition challenging the selection process that this is not followed and it is fraud. Alright.
No, Milord.
Assuming the worst case, it is fraud. Whatever it is, they are serving since last more than 6 years.
Yes.
And is it not required that you should join them in the parliamentary proceedings?
Additional representative capacity, every high court has a rule. You can publish.
Milord, kindly consider one thing. Milord.
One question, is it not required to join?
Milord, in larger interest with the larger public scam.
Don't use the word larger
Scam,
interest.
Lord. You can't
Don't use the larger interest is also there at 30,000.
You lost 30 to 80,000 meritorious candidates are on the street. 80,000 meritorious candidates are on the street. Lord, may I just point out, Lord, the person
Even now, they have not been allowed to join.
yes, amount of money Milord has been recovered from the Milord concerned minister's house. Girlfriend of concerned minister's house. Now, Milord, Milord, this is Milord, the Supreme Court, Milord, this court, Milord, time and again has said that this, in this type of cases, Milord,
Like, have you taken all these pleadings in your interpretation? No. If you have not taken, please, then so you are appearing, not appearing in first time in the Supreme Court. Not appearing first time in the Supreme Court. You are appearing, you can take only those pleas which are used, you have taken before the learned signature and the division bench. So don't influence by all this.
no, Milord, I just may submit. In the repetition, I have not taken. Subsequently, when the pleadings, Milord, objection and exception, all these things came, Milord, I have taken all these points. All the exception, Milord, in the
Without pleading, suppose you have taken this pleading, then you are supposed to join those persons as a part of the proceeding.
Yes.
They can meet out those allegations. In a 226 petition, we cannot deal with like this.
May I submit one thing?
We cannot go for a roving inquiry for every case.
I am appealing for all the respondents.
Milord, so far as the repetitions are concerned, Milord, I am appealing, Milord.
No, the respondents in the
Yes.
Are you agreeing in all these things?
You better have the writ appeal argued there. Oh, is it an LP?
Yes, sir, appeal.
Argued there, let there be subject to what brother says.
Better we set aside to that extent. Or like we say that much part also. We say, let the writ appeal, you go and request both parties and let it be decided at an early date. That is the right way to deal with the issue. If you go, all parties are here, board is here, state of West Bengal is here.
You don't want to create a hope in the mind of thousands in the new selection. And then if the order is set aside,
Then you can understand the consequence also.
The consequence.
That the opportunity must be given by the court and we state that much part only All right, you go both.
May I submit one thing, subject to your lordship kind of approval. But your lordship not court blood in time and again says blood in Kishan Jadav's case and other cases. But these type of cases, blood, the principle of natural justice has not to be followed in true sense and terms.
No, here also you see you have to sift the chaff from the grain. Is it so large that the whole selection have to be settled?
Similar
Bombay case.
Income tax inspector
Column, and then there is a Bombay education matter also.
There is also a matter of Tripura High Court judgment.
Is it so large?
10,000 appointments were cancelled. 10,000 appointments were
So
cancelled.
large as to vitiate the whole.
Somebody has to plead it, Lord. There is no pleading. The legal side is carrying on
That is why we are saying, Mr. Patwalia, you have a right to say there.
Yes,
Yeah,
I fully agree with what your lordship is saying.
So we state that consideration part.
One thing.
And we say, let go and decide by the
Have the
appellate court.
Correct.
They will hear and decide within 3 as expeditiously as possible.
Yes,
We say this.
Correct. May I submit one thing, subject to the lordship approval. But as so far as board is concerned, board as on date should not be an agreed person. May I say? So.
Resources. You see, they have to have the whole selection, mobilize people.
No, it is not. They have not filed any appeal. They have not filed. What they are saying is, these are their difficulties.
We have filed. It's not filed. I have submitted one thing.
They have filed one.
Yes, they have filed appeal.
That is SLP 1307.
Yes, 57. May I submit? Subject to lordship approval, may I submit? But today, the direction given by the honorable single judge as well as approved by the honorable division bench. The board was directed to start the selection afresh for the purpose of selecting the best candidates.
So pending appeal, you see.
Pending appeal will not. Selection process will not be proceeded with. Ultimately, your lordship experience will not appeal. Yes, they
are not saying. We have understand that this order primarily what the court has to state primarily. So we are saying that we are staying this much part. Also, you go raise all your grounds and contentions.
They should be. But as the party, I have no quarrel with that.
Yeah.
The thing was, my lord, it started with 140, my lord. If your lordship may kindly see, my lord, page 4. It started with 140, my lord, petitioners. Then, my lord, came a
Off between you and your appeal for all the respondents.
respondents.
So, clear on that, no?
I am clear, my lord, that at least, my lord, because it did not start with the 36,000 issue, my lord.
On a matter of service, because.
If the names are furnished by the board, we will serve them.
No, you are their petition. I'm asking
our petition, my lord.
Here in the respondents. You are appealing for respondents.
For respondent.
Between you are appealing for all, no?
I am, there is a balance.
These are the writ petitioners in the High Court.
Petitioners, some writ petitions I have there. It started with, my lord, 140. One finding, I briefly one.
He was saying something. Let him finish.
Lord, it started with, Lord, if your lordship sees, my lord, page 4. It started with, my lord, 140 petitioners. Why 36,000 are not added, my lord? Your lordship may kindly see me. Page 4, the first paragraph by the said impugned judgment. The Honorable Single Judge considered the claim of 140 petitioners. Now what happened, my lord, is that, my lord, there was a publication, my lord. Now the last line of the same page. Though through the said publication dated 20th November 2022, the board also disclosed the last line, my lord, page 4.
Yeah, last line.
So they published a booklet, the board. Through the said publication dated 20th November 2022.
No, that is booklet on the website.
No, my lord, they disclosed the comparative marks of the candidates who had appeared, all the candidates.
No,
so that opened the Pandora's box.
Before the writ court, were the selected candidates there to answer all this?
No, they were possibly not there.
At least in a representative.
1,000 were not there because the rebuttal was against the board. Not a single one was there. It was against the board.
At best, there must be some representative.
It opened up before the same.
Just try to understand.
Yes, Lord.
Here it is an appeal by whom? The persons who are affected.
Correct, Lord. And the board.
Alright, they were not a party and by the board. Alright, they have come before the writ appellate court. Before the writ appellate court, they are coming. Other persons who have not come, meaning they are right, they are representing that they should be heard by the writ appellate court, and this selection part, the procedure must be stayed and let them heard and decide. And let it be. Otherwise, if we start staying of this, issuing notice, you can understand what would happen.
I agree there.
Better is
We will make their parties.
There used to be one Prabodh Verma's case which used to be
87,
84 or something.
85 volume.
You have to implead it. Actually, the
Executive capacity.
One paragraph of fine.
Interestingly, my lord,
Just a minute, why? Finding just Please find.
two important things your lordship may see, my lord, because the board will not, before the single judge holds is that category-wise candidates list was not furnished. But this is a very important issue. In a number of matters,
all these issues,
they just not the names. I have appeared in several matters.
Mr.
They just give the names without giving the rank, position, category-wise, and this opens, my lord, everything. It is the most, my lord, important thing to be seen, my lord, that they never publish the rank.
I'm sorry, I don't know how that is a generalized statement. I have been.
No, this is not generalized.
I do not know
It's not generalized. I'm so sorry. The board has to answer this question.
Wrong to make any application under the RTI Act also.
Why should
From 2006 you act. Now everything is depending not when the court proceeding is going on and the
what we are saying to you, all the issues are on the merits.
Yes.
It can be looked into by
Madam.
why we should look into.
Correct.
They will say you will answer on
Correct.
all these we have to see. We are not going for a routine.
Madam.
We are saying only this much part, which is on the page 22.
Right.
Last para. However, the board, we are saying this much.
Correct.
We are not saying anything. Staying this, by the consent, we are saying that it will be decided by the.
Sir, kindly fix a specific time so that we are in honorable
We say expeditiously as possible, because if we fix some time and the parties are not in a position to present the documents or otherwise, and then they will take a plea further coming year that we could not give an opportunity.
The 36,000, if the names are not there, they can file application.
We are
for
only
it.
saying that appeal.
They have not made such
Wait, appeal.
We are 8 persons have come. We are not saying anything.
Greatly, correct.
Now the High Court would look into other persons are coming.
Correct.
They will intervene. They come. The High Court would look into. We are not going to see anything.
Greatly obliged.
The High Court has already decided to look into the matter. The only three parties to be looked into.
Let him make. Let my lord make.
This is the shortest
I think
argument.
probably we should.
This is the shortest argument from you.
Yes, Mr. Singh, you want to
Your argument. Apologize for the late arrival.
Oh, you always come
I'm
late.
not saying a word more. I'm on the right side this time.
What do you want to say? What do you want to say?
Nothing. Your Honours.
You're happy that the matter prolonged.
Absolutely right.
Well, but court one was also
Absolutely
prolonged. I was on my legs. You should not forget your days at the bar, Manu, so soon. Soon.
That's it.
So there is a degree of estoppel applying for a
I
while.
think you will be happy. I have a good support from
Some member of estoppel for a while.
you take it. This is arising out of an order dated 19/5/2023 passed in various MAT 873, you check it. Okay? Numbers are there. MAT numbers 12. Passed by Division Bench of the Calcutta High Court. Before whom the judgment dated 12th May 2023
Yes.
passed by the next single bench in WPA number 21187/2022 was under challenge. The petitioners have raised a grievance before the Division Bench of the High Court of Calcutta that they were not a party before the Red Court, and the entire selection process to the post of assistant teachers.
Primary assistant teacher. Assistant teachers within bracket untrained.
No. Assistant teacher.
No, primary schools. Primary schools. But we were in the untrained category. You're not.
We are saying now.
If we are trained, now we are
only untrained.
we are not asking.
There are different.
This selection was with respect to
Assistant teacher and yes. No dispute.
Assistant teacher.
California.
In the entire selection.
In matter challenging the matter of selection to the post of assistant teacher in bracket untrained. Full stop. Ab over. Past by division bench of the Calcutta High Court. Before whom the judgment dated 12th May 2023.
Yes.
Passed by the single bench in WPA number 21187 of the 2022 was under challenge. Full stop. The petitioners have raised a grievance before the division bench of the High Court of Calcutta that they were not a party before the Red Court and the entire selection process to the post of assistant teachers.
Yes, primary assistant teacher. Assistant teachers within bracket untrained. No. Assistant teacher. No, primary school. Primary school. But we were in the untrained category. You're not untrained now.
If we are trained, now we are
only untrained.
we are not asking.
There are different.
This selection was with respect to
assistant teacher and yes. No dispute.
Assistant teacher.
California.
In the entire selection.
In matter challenging the matter of selection to the post of assistant teacher in bracket untrained. Full stop. Ab over. The direction as issued by a single judge is in gross violation of the principle of natural justice without joining the affected person as a party to the proceeding and affording them an opportunity. Full stop. The division bench of the High Court of Calcutta has considered this said aspect and by granting the interim relief, page 22, at page 22, the court observed the court has granted the stay on the termination of the appellants, but also observed as thus. You please page 22, A to A. Full stop. The court
Yes, sir. Matter shall be for appropriate way.
Bring the aforesaid. Court said the matter shall be placed before the appropriate division bench in the first week of September. Full stop. The primary contention which was advanced before this court is that the petitioners were not a party before the Red Court. However, their selection cannot be set at naught with a further direction to hold a fresh selection in a time-bound manner. This also urged that when the division bench, by considering the interim prayer, had stayed so far, stayed the order in view, so far as it relates to termination is concerned, because they were not party, then the other direction to hold a fresh process of selection, terminating the services of the affected person is not proper. Therefore, staying the said part of the order, the parties may be relegated to before the division bench to raise all the contentions and the grounds which may be directed to be adjudicated in a time-bound manner, looking to the nature of the controversy as involved for the writ court as well as for the writ appellate court. And a council representing the writ petitioners and the state writ petitioners. Council appearing on behalf of the board. Learned Senior Counsel Gupta appearing on behalf of the board. The students that the selection was of how many peoples? 32,000.
32,000. Sometimes the learned judge is saying 36, sometimes he is saying 32. What is the basis?
Approximately 35,000.
Approximately 35,000. 32,000 assistant teachers.
What is the basis?
Somewhere it is 36 also. He has changed that order. He has changed.
Subsequently order correct.
Let me take it.
Change it on 6 of the
You see, you will find the answer of it. Appears to be more than 30,000 assistant teachers in the country. To call them and to hold a press interview within the time frame is not possible. In addition, it is a expensive exercise which cannot be possibly done. Full stop. On the other hand, the council appearing on behalf of the writ petitioners contains defended the orders of learned single judge and contains that once the process of selection is found at fault and the interim relief regarding termination of the services of petitioners have been directed by the writ court, interference may not be warranted in this case. After having heard learned counsel for the parties, without expressing any opinion on the merits of the facts and the legal position as brought to our notice, we are impressed upon only one submission, that the order passed by learned single judge is without joining the petitioners,
even in a representative capacity.
joining the petitioners as a party or even in a representative capacity in the proceedings. Full stop. We are further impressed that once the said contention was found merit before the appellate court while granting the partial interim relief, at that stage, issuance of the direction for
Holding for selection.
conducting the selection as directed by learned single judge is not justified. Full stop. Therefore, we set aside the interim order to the extent of issuance of the direction to conduct the selection afresh as directed by learned single judge. Full stop. The said order is subject to final outcome of the orders of the writ appeal, orders in the writ appeal. Full stop. We have already on the cost of repetition, it is made clear here that we have already expressed that we have not considered the merits of the contentions of any of the parties. However, they are at liberty to raise all those contentions before in the appellate court, which shall be duly
On its own merits.
considered on its own merit.
Including the natural justice. You can raise that it is not required. It is a huge fraud. Impossible to raise all that.
All contention. Before the writ appellate court. First of all, considering the fact that it's a matter relating to selection and appointment of the last number of the assistant teachers, we hope and trust that such controversy ought to be decided with an earliest. Therefore, we request the High Court to expedite the writ appeal. As expeditiously as possible.
And accept notice, otherwise we will be committing.
The so and so accept notice on behalf of the great petitioners on the top. Okay. Then by consent of the parties, the case is heard.
Item 58, permission to file SLP may be granted. We are item 58.
Why you are not in the writ appeal?
We were not in the writ appeal, but our services were terminated, so we have come here. 56, 57.
Permission.
No. It's only a permission case.
Permission.
No, not 56, not permission.
11.1 and 2 say.
Permission.
Permission. 57.1.
You are doing a hop, step and jump.
Just be clear, be clear. 57 and 1 and 2 and 58.
7.1.
Only one. In any other case in which permission issues there?
No. Not for all.
Right. In other cases, anything want to say?
No.
Very comprehensively.
Very
technically worded.
I have patient.
Very well.
Please change the nomenclature. It doesn't sound good. Untrained teacher.
No, exactly, Milord, I wanted to do that.
Please change.
No, exactly, I wanted, Milord, just a minute. That was earlier the provision was that, Milord, that untrained can be file an application. The provision Act has been amended and it has been said by 2019 all have to be trained and all we are trained. Therefore, I wanted to say, don't say now untrained now I am not untrained now. I am trained.
No, my lord.
What does your rule say?
What untrained is being used is only with respect to that selection process.
Exactly. Not for any other. Yes.
Only to contrast between those who undergone.
These were the exemptees under 23 of the NCTE Act.
Yeah.
Your Lordship remembers that 5-year period.
Yes.
Initial 3, then 5. So this was that exemptee under that exemption period.
People who came on the benches.
Lordship, if I may just supplement,
Employees as well as board are disposed of.
effectively what has happened in before 2009, there is no so much colleges in all over the India. There's a real relaxation has been made up to 31st March 2009.
Lordship, in fact, the original vacancy did not differentiate between untrained and trained. The Act required first to whoever passes the TET examination and trained, give them appointment, then whatever is left out to be given to untrained. That's as per the scheme. So the recruitment process is a same.
Mr. Kunal, I was only saying you may call them exempted teachers, you may call them.
That's what the
Statutorily exempt.
Untrained part of it.
Lordship, I have filed an. Can I put in another word? You are fighting for teachers, employees, alike. Those are for education. Think one point. Now this education has come down to literacy.
Education has come down.
Lordship,
Literacy. And therefore all this teacher, Guruji, all this. Think of it.
This what Mr. Chatterjee was telling, but
Now on the matter is over.
amended.
May I say one thing? This is a scheme. Not your lordship appreciate not inter thing is not under scanner.
not similar.